Transcript that his White House released this morning of a phone call he had with the Ukrainian president, a phone call that has gotten him in a lot of trouble with Democrats, one that has sparked the opening of a formal impeachment inquiry. Question is, though, are the things that are in this transcript actually impeachable? What constitutes an impeachable offense? How do we know if what's in this partial transcript is impeachable? Let's bring in an expert on this. Tom Jipping joins me now from Washington, D.C. He is the Deputy Director of the Edwin Meese III Center for Legal and Judicial Studies at the Heritage Foundation. Tom, thank you very much for being here, sir. I appreciate your insight and your time.
Thanks for having me.
I wonder, first of all, how well defined an impeachable offense is, a high crime misdemeanor. What is the criteria removed from what we know about what this president has done and what Democrats say is or is not impeachable in this case? Removed from that, what do our founding documents and our legal interpretations say about what the criteria is?
Well, there's two different ways to look at that. One is somewhat more historical and maybe academic. The phrase high crimes and misdemeanors, it might sound one way to us today, but the real issue in interpreting any provision of the Constitution is what did it mean to those who put it in the Constitution? And that phrase had been around in English common law for a couple of hundred years. In general, we're talking about serious misconduct by an official that really makes him ineligible to be in office anymore. I mean, it's considered to be kind of an offense against the political system, an offense against the American people, something that's really sort of broad and deep, so that he has to be removed now, as opposed to waiting, for example, till the next election. In a system like ours, elections are usually how, people evaluate and kind of pass judgment on the president. So it's a narrow category of very serious misconduct that requires someone, in the case of the president who's been elected, to be removed now.
Something that Representative Justin Amash, now an independent, had cited when he came out in support of impeachment was that it's something that constitutes a breach of public trust, which seems to be a broader definition than this sort of narrow scope that you have defined. Is it fair to say that breaching the public trust in this executive role that oversees many people who may disagree with the executive is enough to constitute impeachment?
Well, the second way of looking at it that I began to describe is simply that the Constitution gives the sole power of impeachment to the House of Representatives. So in a very literal sense, and this is something that Justin Amash's predecessor in that district in Michigan, Gerald Ford, said when he tried to lead an impeachment against a Supreme Court justice. He said, an impeachable offense is whatever the House of Representatives says it is. But that phrase, breach of the public trust, I think it's consistent with what I was describing. And that's the best we can do, really, drawing from history, is that sort of broad outline. The fact is, though, only 19 officials in all of American history have been impeached, and 13 of those have been judges. So it's a step that it's been taken very rarely. And as I say, the basis for a political system like ours is elections. So it has to be something where the president's conduct is so serious that we can't wait till the next election for the people to express their view on it, but he's got to be removed now. I don't think there's any other way to look at it, but that is a very narrow category of very serious misconduct.
Something, Tom, that could help inform lawmakers' idea of whether or not the president should be removed, should be tried in the Senate, is the details of this whistleblower complaint about a series of actions reportedly that concern someone in the intelligence community so much that they went to the Inspector General of the intelligence community. We have just confirmed here at Newsy that the House and Senate Intel committees have that complaint now. And so now lawmakers may begin to get a better understanding of what's in it, obviously, if they're going to review it. Is it your take, your understanding of the impeachment process, that really it's a very subjective interpretation based on who's making up the legislative branch?
Well, it certainly is, and there's no requirement or guarantee that this one document will in fact be the basis for any impeachment in the future. I mean, the House of Representatives can vote to impeach or vote for articles of impeachment that have nothing to do with this conversation with the Ukrainian president at all. So while this document, and by the way, it really isn't a transcript, the document itself says that it's a compilation of recollections by people who were in the room. That document is kind of what sparked the latest little flurry of controversy, but there's no reason, there's no requirement that the House itself has to limit anything that it does to this particular incident. In fact, the first articles of impeachment filed against President Trump were introduced in the middle of 2017. Democrats have been, pushing the idea that somehow what he's been doing is impeachable for quite some time. So there's no reason to expect that it would be necessarily limited to just what this incident is about.
Tom, I wonder, based on all of this legal grounding, this context you've given us, your reading of the summary, the summary of the parts of the transcript that we have, are you troubled by what you see in this memo?
Well, again, this isn't a transcript, and the things that are in it can be read different ways. And that one conversation itself has a lot of context, which neither you nor I know anything about. So at the end of the day, the House moves forward with impeachment only when articles of impeachment are introduced, the Judiciary Committee considers and reports them to the full House, and the House votes for them. And then, of course, as you alluded to earlier, the Senate has to conduct an impeachment trial. You have to have 2/3 in the Senate to get convicted. So, both Andrew Johnson and Bill Clinton were impeached, but neither one of them was removed. So this is very early in this process. For all we know, there will be a lot of different things coming out, discussed, dismissed. One day we think that something is a smoking gun. The next day it falls flat and it means nothing. It's way too early to speculate about such things. And again, this is a decision that only the House of Representatives can make.
So, Tom, quickly then, the process here has to be respected. And what I hear you saying is that whether or not it's impeachable will be determined by the process.
Well, the Constitution says the House has the sole power of impeachment. That provision means what it says. And ultimately, the House has to decide. An impeachment is like an indictment. If you're sort of generally familiar with the criminal justice system, it's an accusation, it's a charge, and the House has the sole power to do that. I just hope that the place that impeachment has in our constitutional structure will be respected, that it won't be used for more narrow political or partisan purposes. And that there can be an objective evaluation of this, because, as I've said, elections are really the way that we ought to decide who we want to have as our leaders.
Tom Jipping with us from the Heritage Foundation. Tom, thank you very much. I appreciate your time and your expertise on this.
Thanks for having me.